Hello, ladies and gentlemen. I am Roger W. Knight, and I would like you to meet some of my new friends. I have Officer Stone Wallingford. Isn't he beautiful? And his partner, Juanita Kirkland, and their K-9 unit, Blitz Krieg. Aren't they just the most beautiful police officers in the world? Stone Wallingford is a regular Dudley Do-Right. He's tall, he's strong, he's clean-cut, handsome. There's not a crease out of place on his uniform, and his shoes and gun belt are shiny. He is just an absolutely beautiful man. And when he goes to court and testifies on behalf of the prosecution, he is a nightmare for the defense lawyers. And the reason that he is a nightmare is that when a beautiful man in uniform, an authority figure such as Stone Wallingford, Officer Stone Wallingford, gives testimony, he can tell the jury that the ocean is not salty, and they will believe him. You see, juries tend to give police officers a bit more credibility, a bit more judgment for their credibility than they actually deserve. And this is really crucial because I'm going to show you the most important jury instruction in just about every civil and criminal trial. You see this jury instruction, and if you read it carefully, there's a lot of other verbiage in these jury instructions, but this is the key one. And the key one reads, you are the sole judges of the credibility of the witness and how much weight to give his testimony. That is the basic jury instruction. And if you are not aware of this instruction, and if you do not take it into account, you're not doing your job as either a prosecutor or a defense attorney. Because that's the rules of the game. If the jury believes the prosecution witnesses, but they don't believe the defense witnesses, your client goes to jail. And that's just pretty much it. Whether he's actually innocent or guilty of the crime doesn't change the fact that if the jury believes the prosecution witnesses more than they believe the defense witnesses, chances are you're going to lose the trial. Now, there's very, very important things, and I think the reason for this, I have to tell you about a sneaky peek in the hearsay rules. First of all, I'm going to show you the basic evidence rule 802 is the hearsay rule. Hearsay is not admissible except as provided by exceptions in the rules or statutes or some or laws and whatnot. Unless there's an exception somewhere, hearsay evidence is generally not admissible. Now, what is hearsay evidence? Well, we have Rule 801C, and it tells you what hearsay is. Hearsay is a statement other than one made under oath by a witness that is presented to provide evidence of a proposition, of a factual proposition, the truth of the matter asserted, other than one made by declarant. But now we have, in that same hearsay rule, subsection D, subsection 2, statements which are not hearsay. And you see a lot of verbiage in there. But I'm going to show you in highlighted format the real key issue when it comes to police officer testimony. And that is this. Admission by party opponent. The statement is offered against a party opponent, against a party, and is the party's own statement. Now, what does that mean? What does this mean in practice when it gives testimony given by Officer Stone Wallingford, who's on the witness stand? Well, here's the practical effect of this. Officer Stone Wallingford takes the witness stand, and he makes all these, gives all this testimony as to what happened in his interview of your client, the defendant, the party opponent. And statements made by your defendant that he witnessed and recorded would ordinarily be hearsay statements, because Officer Stone Wallingford didn't, unless he witnessed the events that the interviewee that your client is describing, it's hearsay from his point of view, anything that your client said to him. But if statements made by your client tend to make him look guilty, support the proposition that he committed the crime of which he is charged, that's admissible because it's actually defined as not hearsay, even though otherwise it's hearsay. However, if, while representing your client, after Stone Wallingford gives his testimony, you go and go up to cross-examine Stone Wallingford, as is your right, as is the criminal defendant's right. It's called the Confrontation Clause. The Sixth Amendment says that criminal cases, defendant has the right to confront his accusers. And this is also true in the state constitutions. All 50 state constitutions have provisions like that. In Washington Constitution, it's Article 1, Section 22, has a lot of these rights set in, including the Confrontation Clause. In fact, one of the big reasons for the hearsay rule was to provide a practical means of enforcing the Confrontation Clause, so that you have the opportunity to cross-examine every witness against your client. So you go and cross-examine Officer Wallingford. Officer Wallingford testified about a bunch of statements that your client made that makes him look guilty. So now it's your turn to cross-examine and say, well, Officer Wallingford, during your interview of my client, didn't he say something about being in Tacoma that morning? Objection! Hearsay! Well, what happens? Well, the defense attorney, the prosecutor screams, objection. And the judge says, sustained. But, Your Honor, I offer this statement, you might call it a sidebar, and you might say, well, look, this goes right to whether my client was present at the scene of the crime. If he was in Tacoma that morning and had difficulties to get back there, and he told Officer Wallingford this, yes, and your client will have every opportunity to testify to this when he takes the stand, when you get to present the case. So, the objection is sustained. Well, wait a minute. Now, what's going on here? Remember, the jury is the sole determiner of the credibility of each witness and how much weight to give them. Here is this authority figure in this uniform, a man whose morality is just beyond assault. You know, I mean, you just can't besmirch his reputation without really strong evidence to besmirch him. He's a neutral party. He doesn't care if your client committed the crime or not, or so he says. So everyone pretends. The jury is going to give his testimony a lot of credibility. He's an authority figure. And the way the voir dire works, it tends to eliminate those jurors who don't like cops. And you wind up with the nerds you knew in high school, and that's your jury. And they see police as authority figures. They see police as a thin blue line between them and the chaos of criminals and disorder in society. So they're going to give Officer Wallingford testimony, and his partners, Juanita Kirkland, they're going to give their testimony a lot of credibility. But there's a limit to what each police officer can tell the jury when it comes to hearsay statements. Any statement made by your client to an officer that makes him look guilty is admissible because it's not even hearsay according to the rules. But any other statement he makes that would tend to show him that he was not at the scene of the crime or that he did not commit the crime is inadmissible as hearsay. So so you have a one-sided rule. The man who has the credibility in the eye of the jury is not allowed to testify in favor of your client, the defendant, as to any evidence and knowledge, hearsay knowledge, of statements that your client made that makes him look less guilty or makes him look innocent. He can't testify to that. It's inadmissible. So this is a bit of a one-sided rule. And I would propose a change in these evidence rules, where if you have a government employee, a public servant, such as a beautiful, handsome police officer, whose job it is to interview witnesses and suspects and people who have been arrested to determine whether or not they committed crimes and to gather evidence that they committed the crimes, evidence against them, which is their function as police. I fail to see why they cannot also testify as to any statements that a defendant makes, a party opponent makes, that would tend to support his innocence, support the proposition that he did not commit the crime, exculpatory evidence. And that's one change I would suggest